You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 1. What is intellectual property and what kind do I need? My name is Dr. Adam Diamond, founder and owner of Diamond Patent Law in Los Angeles, California. And I've been a patent attorney since 2008, and I created this podcast for the budding entrepreneur, inventor, startup companies that just want to know how to actually get a patent on their idea. The patent application process can be a bit scary, so the plan with this podcast is to take you step by step, starting from the time you get an idea in your head to actually getting an issued patent. Each episode is going to take you one step at a time through the patenting process, so that by the end of the series, you'll have the tools to prepare and file an application all by yourself, or if you'd like to have a patent attorney help you through the process, by listening to this podcast, at least you'll know the right questions to ask your attorney. You can contact me at patentingforinventors.com. That's patenting, F-O-R, inventors.com. This first episode is going to be about general intellectual property and the types of intellectual property that you might need for your idea. Now, you may have heard the terms intellectual property, patent, trademark, copyright, trade secret thrown around, but you don't really have a good understanding of the differences, and you may not even know which one applies to you. But all that you do know is that you have something, or you thought of something, that you don't want anyone else to steal. So in this first episode, I'm going to do an overview of the 4 main types of intellectual property and give examples of each so you have a better idea of which one you might need. Your invention or product may fall into just one type of intellectual property. It could just be a patent, it could just be a trademark or a copyright or a trade secret, but it's possible that it could fall under all 4 types. And I'll go through at the end an example of a product that might be covered under all 4 types of intellectual property. So before we begin, we have to first understand what is intellectual property. And intellectual property refers to creations of the mind that can be protected by law. There are 4 main types: copyrights, trademarks, patents, and trade secrets, and I'm going to go through a very basic overview of each of these first. Copyrights are the first area, and copyrights are meant to protect original and creative expressions. The most common things you might get a copyright for are music, paintings, books, lyrics, movies, dance choreography, and product manuals. It doesn't cover the underlying ideas, so 2 movies can be about the same topic or idea, but if they're entirely different scripts, you aren't prevented from making your movie just because someone else had a movie about the same idea. Also, you can't copyright facts. For example, the phone book, even though it's a book, and books are generally copyrightable, in this case, it's not copyrightable because the phone book is just facts of names and phone numbers. There has to be something original and creative in order for you to have copyright protection for your work. It also has to be in some physical form. So even though I said dance choreography, there's only copyright protection if it has been recorded in some physical medium, such as on video or written out in dance notation. So if you have thought of something that fits into one of these categories, you are probably interested in copyright protection. Copyrights today generally last the life of the creator, plus 70 years. So once the creator dies, for the next 70 years, the heirs to the creator can continue to collect royalties. And after those 70 years are up, then it becomes public domain. The next category of intellectual property are trademarks. Trademarks are sometimes confused with copyrights because they both can be made of words or designs, but the difference is that trademarks identify the source of the goods. So the question is, when you see this word or design or slogan, is it telling you about what company or business it came from that differentiates it from other companies? For example, the Nike swoosh. When you see that on a shoe, you know it's Nike and not Reebok. When you see the peacock on TV, you know it's an NBC show and not a CBS show. Trademarks can also be slogans, such as "Just Do It." When you hear that slogan, you know it's Nike. When you hear the slogan "Don't Leave Home Without It," you know it's American Express and not Visa. Now, what's great about trademark rights is that they can last forever as long as they're continuously used. Now, once they stop being used by that company, then anyone can start using that mark. The third category of intellectual property are patents. And this is going to be the focus of this podcast. Patents protect inventions. The invention can be an improvement for something already known, such as maybe inventing a new kind of battery that can last twice as long as known batteries, or inventing a new medical device that makes heart surgery easier, or creating a new drug that fights cancer. The invention doesn't have to be a physical object, but it can be a method of doing something. For example, someone might be able to get a patent for a method of refining oil, and this method may involve steps that are cheaper and more easily make gasoline out of oil. Now, the focus of this podcast is going to be how to get these types of inventions for physical products and method patents, and together these are called utility patents. There are two other kinds of patents, which are design patents and plant patents, which I'll cover briefly in some later episodes. Patent rights generally last about 20 years from the time of filing, and once patented, you have the right to stop people from making, using, importing, or selling your patented product. After the 20 years are over, anyone's free to copy your invention. The last category of intellectual property are trade secrets. Trade secrets are exactly what they sound like. They're secrets. And as long as they remain secret and no one can figure out what the secret is, then you may have a business advantage. A trade secret is usually confidential business information, and probably the most famous example of a trade secret is the exact formula for Coca-Cola. Now, there's an urban legend that only 2 people know the formula for Coke, and they're not allowed to be on the same plane together in case the plane crashes and the formula is lost forever. Now, the urban legend isn't true, but it is true that very few people know the formula, and it's a very guarded secret for the company. So why don't they patent it so no one can copy it? And there are actually a few reasons why, but one of them is that if they patented the formula, what they would have to do is disclose what the formula is in their patent application, and then after 20 years, anyone could make the formula. And that goes to one of the benefits, but also one of the problems of trade secrets. A trade secret can last forever as long as it is kept secret, but if the secret gets out by reverse engineering the formula, then anyone can try to recreate Coke, and there's nothing that the Coca-Cola company can do. Businesses often use what are called non-disclosure agreements, so that employees are barred from revealing the secrets of the company. But once the secret gets out, you can't then go after the public for using that information. As I mentioned in the beginning, whatever your idea is, it actually might be covered by all 4 types of intellectual property. Now, one example is, let's say you have a new kind of watch. You may have discovered a new way to connect the gears so that the watch is much more accurate. The way you connected the gears might be covered by a patent, but let's say you also designed a new watch band with a particular new pattern or an image on the face of the watch, and these would be covered by copyright. And you might also want to put your logo on the watch, such as Rolex or Timex or Casio, and these would be covered by trademarks. And let's say the leather you use in your watch strap is the best leather in the world. You don't want others to know where you get this leather, and you keep it a secret, and your leather supplier could be your company's trade secret. So these are the 4 areas of intellectual property: copyrights, trademarks, patents, and trade secrets. In the next episode, I'm going to cover the steps to go through when you first have an idea for a new invention to start you on the patenting process. Until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.